But with regard to the 360 additional defense lawyers that are going to be needed for the 360 outstanding cases, equal amount of additional counsel on the Department of Justice's side, all of the additional investigators, all of that, you factor all of that into your cost analyses?
We do. I think the one slight difference is that we do think that the legislature actually does have a choice in terms of whether to expand both the Office of the State Public Defender and the HCRC. The initiative has a component that allows for changes to be made in furthering the intent of the initiative by a vote of 75% of both houses. And so to the extent the legislature decided that it was a more cost-effective way to increase the number of attorneys at the Habeas Corpus Resource Center, to give you, which is absolutely right, it's included. The legislature certainly could do that because the intent would be to expand the number of available attorneys. I think you have separate questions about qualifications and things like that, but to the extent that the legislature wanted to change the number, there is a mechanism potentially to do that.
Okay, and then just two very last questions. With regard to the Supreme Court needing to triple the number of cases that it would have to determine, is there a possibility that they could have they would have no time to deal with the 2/3 of their caseload?
So our understanding,
currently?
Oh, I'm sorry.
No, go ahead.
Our understanding is, in our conversations with the Supreme Court, is actually 25% of their time. It's a little bit lower. It will be a choice in terms of how the Supreme Court balances their workload. There could be a little bit of flexibility in terms of, to the extent other workload is coming forward to the Supreme Court that have other time parameters in place, they might seek to address that. It's unknown to us whether or not the Supreme Court would shift to a wholly, all they're hearing is death penalty cases.
Okay. No more Supreme Court questions. Lastly, with regard to the trial court, 270 additional trial court judges are needed just to handle today's workload. Is this going to cripple the trial court system, and what would happen to civil litigants? Are they going to get locked out because there's going to be so much on the criminal side? In fact, we know the courtrooms are already closing now, courthouses are closing now. How will the trial court system manage this?
So when we do our analysis, we factor from where the state is currently at now, and then we estimate the costs that we think it would take in addition. So, for example, when we're thinking about the workload to the courts, when we build our cost estimate, we're saying we think it'll cost this much, and if you give this much to the courts, it's specifically for this workload. So that's how we kind of think about that. I think that there are larger questions in terms of how the trial courts manage their workload because you have these time frames. And so there are questions about whether or not additional staff would potentially need to be diverted, et cetera. I think that it's yet another one of those. We went through a whole list of factors. It is another one of those factors that would need to be that would be at issue here. And
just finally, what is your time frame when you come down to your final cost estimate for purposes of the ballot, the voter pamphlet?
So our materials are due to the Secretary of State's office by the middle of July.
And so you're scrubbing numbers until then?
A little bit before then, because one of the things that we're also tasked with is when we prepare these ballot materials, we're required to present the information in a way that's easily accessible to the average voter. And so some of the things that we try to do as part of that process is we may try to simplify the terms that we use. We might not go as far in depth, so we try to kind of limit some of the complexities. This is one of those that's right for that because there are lots of moving parts. So that being said, our materials are prepared a little bit in advance because we like to test them against average readers. Sure. But in terms of updating our models and estimates, we are moving, we are going through that process, and we continue to do so. So we continue to have conversations.
Great. Okay. Thank you very much, Madam Chair, and thank you, Ms. Lee.
Thank you. Another question was triggered in my mind by some of yours, Senator Leno, but I can't fully recall. Is there a time limit on the Supreme Court to make a decision?
Under the new measure?
Under this initiative.
So It would just be the 5-year limitation on both the direct appeal and the habeas corpus petition. And so you could arguably say there's a little bit of a question about timing the cases.
Like if you got it at the Supreme Court 4.5 years later, you'd have to decide it in 6 months, or the claim would be dismissed?
So the claim wouldn't be dismissed. The intent is it's supposed to be handled within 5 years. To the extent that there was a delay that was not justified, and the justification in the initiative is, I believe, also extraordinary circumstances, attorneys would be able to file a writ in court asking for the case to move along. There's no real, for lack of a term, penalty, because the sentence still stays in place, the court procedures would continue to move forward, and so it's not quite clear what the consequence would be.
Let me just try, because I can't go back and read the whole thing right now. Is there a time limit on the initial return to the trial court?
Of the habeas?
Yes. When the same judge that heard the original case
Can I try?
hears it again.
My understanding of the initiative is that when the person is sentenced to death, according to the initiative, the trial judge is supposed to immediately appoint the habeas attorney. And then once the attorney is appointed, it's a 1-year deadline to actually file your habeas petition.
With that
court, with that judge, yeah. Okay. And then ultimately...
Go ahead. Is that usual procedure that a judge would appoint the attorney that would appeal the judge's decision?
No, currently there are no circumstances in which the trial court judge appoints appellate counsel. All of that happens at the Supreme Court now.
Okay. But there's a 1-year period after the attorney is appointed for the trial court to act. Then it would go to, if there was an appeal, it would go to the appellate court. Yes?
If I can just clarify, 1 year for your attorney to file your habeas, and then the judge has to, is there a specific timeline for the judge to rule? 1 year. 1 year for the judge to rule. So now you're at 2 years.
So you're 2 years. So then if there was an appeal of that, the appellate level, is there a time limit on that?
Not explicitly, but the whole thing has to be under the initiative all the way through the Supreme Court in 5 years.
And the Supreme Court also doesn't have a direct timeline.
Correct.
But you could be talking about then a 3-year period for those two.
Correct.
For those two things.
Mm-hmm.
And if the time period is not met, what is the consequence?
So that was what if there is no justifiable reason for delay, and that's why the extraordinary and compelling circumstances is a big unknown, but it's an important unknown.
But that's different from justified. Compelling and extraordinary is different from justified. Justified is you got an explanation. Compelling and extraordinary has other implications.
I think that is the definition the initiative uses to justify a delay. And so if the time frame is exceeded, then the victim or either attorney on either side would be able to file, I believe, a writ asking for the case to move along. However, leading back to your original question, Senator Hancock, the case wouldn't be dismissed. It would still continue to go on. So it's a little bit...
And who would decide the writ? I mean, we sound like a lot of court cases are, and having to deal with the court requests for additional money every year in the budget subcommittee. It is some concern.
We would have to look into that. It's not coming to the top of my mind right now at this point.
Okay. Thank you.
We could definitely circle back with you.
Okay, thank you. And would you just double check to see if the claim is ever dismissed as a result of not meeting time frames? I thought I read something. like that,
the
but I
attorney
couldn't.
fails to meet the time frame of filing within the 1 year, the initiative does say it shall be dismissed unless there's a colorable claim of innocence in that petition.
That's right. Okay. So that would be
And-
back at the trial court
Yes.
level.
And I know it's late in the day and we're very inside baseball on this, and there are so many practical problems, it's hard to know where to begin. But I'll just point out one because I think it's responsive to your question. The 1 year time limit for filing the habeas petition after judgment is imposed, it usually takes a good part of the year just to get the trial transcript transcribed. So you're talking about having to file a habeas petition without knowing what happened at the trial, and it's just unworkable.
So, Senator Hancock, I think I do have the answer to your question. The initiative language in terms of the failure to meet the deadline, it does say the failure of a court to comply with the time limit shall not affect the validity of the judgment or require dismissal of an appeal or habeas corpus petition. So it wouldn't be dismissed. In terms of the filing, it would be determined by the court in which the petition was filed, and the court would have to act within 60 days of the filing.
Okay. Thank you. That is helpful information. I don't have any other questions. Does anyone else? If not, we will take comments from the public. If there are comments from the public at this time, please come forward to the microphone.
Thank you. This is Nancy Haight from California Attorneys for Criminal Justice. Again and briefly. A couple issues that were not touched upon that involve my organization and the attorneys that I work with is the concept that the Supreme Court will be responsible for handling and managing all these habeas corpus attorneys. From the ground level, I have to tell you that that is practically an impossibility at this time. The Supreme Court is notorious in not paying or deferring paying or partially denying paying for its current habeas corpus attorneys. And this is part of the reason why attorneys who are qualified don't take these cases. So in some cases, the payments are delayed 6 months, some cases 12 months. In my current case, 4 years. And the concept that now the Supreme Court would be responsible for managing and administering all of these attorneys' cases is probably not realistic with the bureaucracy that they have in place today.
Thank you.
Yes. And another thing, too, I just have to say one final thing, and that is that we sit here and we listen to all of this conversation about justice. And what is very clear is that justice for these victims of these cases in this initiative trumps justice for the hundreds of thousands of people who use the justice system today. And for those of us who are in Superior Court, I mean, if I'm in Los Angeles Superior Court and there are 109 habeas corpus petitioners, they will take up 21% of the Superior Court judges. If I'm in Riverside County, where they have 69 habeas corpus petitioners, that would take up 103% of the Superior Court judges. So the question, if you look at these courts, and I mean, those are the extremes, of course. San Bernardino County, it's only 40% of the Superior Court judges who will be occupied by these cases. So you have to ask yourself, where is justice for the small claims court claimants? You know, where's justice for the parents who are looking for support modifications for their children? Civil cases don't have speedy trial, requirements like criminal cases do. And so you just have to wonder, will all these civil cases just go by the wayside? So I don't think that the justice for these few who we feel wholeheartedly for, I don't believe that should trump justice for everyone else.
Thank you. I just have to say, after listening this morning, that you would have to say justice for some victims' families, since we did hear from other victims' families who do not feel that they need that foreclosure.
Indeed.
Yeah, but thank you. I mean, we're talking about victims. I do have another quick question for the LAO, and I'm sorry, but I think because of the hour, I'm losing the sense of the big picture. Was it your conclusion at the end of the day that this initiative would cost the state money?
So we separate court from prison. So on
Why? They're all state costs.
Well, because on the court side we are better able to draw a conclusion on the near term on the court costs, and on the long term, it's definitely uncertain. And so because of that, we don't mesh the two together. So on the court side, in the near term, and by near term, we're talking about as long as you kind of have a backlog of the size that we do, a sizable backlog where you have hundreds of pending cases. On that side, we definitely see on an annual basis, you'll have costs potentially in the tens of millions of dollars. Then in the long run, once you've eliminated most of the backlog and you're focusing on the ongoing cases, day-to-day cases, on that side, then we're less clear on what the fiscal impact will be. You could have, the courts will have to maintain a certain level of staffing at all times. Given the different layers of review, they'll have to do that. But then on the flip side, you also have the potential that each individual case might take less time and cost individually. On the flip side, under certain...
Why would you have that potential?
So in terms of, to the extent that the cases are more targeted and more narrowed, we would be spending less time on the individual petition. That's one possibility. But the additional possibility is that you actually spend more time on each case in terms of the different layers of review, the different attorney costs, and things like that. So we were less sure on the long run, and that's why we definitely said in the long run we have unknown. It's unknown to us. Which is because we have in the near run increased costs on an annual basis, and then unknown in the long run, we separated out the prison because on the prison side, to the extent that CDCR made use of the authority to shift individuals throughout the prison, the cost reduction and costs there were a little bit more clearly easy for us to identify in terms of factoring into a model.
And the timing of those costs could really change. I mean, you could easily see a situation where this measure passes and this administration chooses not to direct CDCR to move the inmates around, but a future administration does, or vice versa. And so the timing is really hard. So to come to a specific bottom of the line number, you need to know all of the costs and when they occur. And because this measure has some uncertainties about it, we weren't able to get there. We just were able to characterize each different aspect.
Okay, and you don't have a net short-term cost?
We don't, generally because there's and we've discussed a number of the different factors at length where, based on the decisions that are made, you can drastically impact the costs.
So, for example, on the one hand, you might look at the analysis and conclude that in the short run there'll be an increase in court costs. However, if in the short run CDCR chooses to capture those correctional savings that are possible and moves the inmates around, that would offset some of that. And it's not exactly clear how those two would play off one another.
And did you find there would be a net saving or a net cost from the initiative we heard this morning?
So in the initiative that we heard this morning, we did find that there would be a net reduction of costs of $150 million annually after the first few years.
Yeah, that could be higher or lower depending on circumstances.
Yeah.
But we did come to the conclusion that there'd be net savings or net cost reductions.
Net cost reductions. Mm-hmm.
Okay. So I guess there's some work to do. Thank you for refining those numbers. Thank you very much. Is there any other comment from the public? Seeing and hearing none, the committee meeting is adjourned. Thank you all very, very much.